Hello, my name is Sampa Karmkar Singh. I am Assistant Professor at WBNUJ's Kolkata. Today we are going to discuss the module titled as Real Estate Fraud. The objective of this module is to inculcate within the readers in-depth knowledge of laws related to real estate sector and to explain basic concepts required for better understanding of the newly drafted legislation, the Real Estate Regulation and Development Act of 2016. After going through this module, the readers will have a clear understanding of the concept of real estate fraud, applicable laws relating to real estate, comprehensive knowledge of the provisions of the Real Estate Regulation and Development Act 2016 and awareness about real estate sector. Franklin D. Roosevelt has rightly opined that real estate cannot be lost or stolen, nor can it be carried away, purchased with common sense, paid for in full, and managed with reasonable care. It is about the safest investment in the world. The term real estate is defined by the Planning Commission as land including the air above it and the ground below it and any buildings or structures on it. It covers residential housing, commercial offices, trading spaces such as theater, hotels and restaurants, retail outlets, industrial buildings such as factories and government buildings. Real estate involves the purchases, sale and development of land, residential and non-residential buildings. The real estate sector in India has assumed growing importance with the liberalization of the economy. The consequent increase in business opportunities and migration of the labor force has in turn increased the demand for commercial and housing space, especially rental housing. Real estate in India is the second most important sector after agriculture, having secondary and tertiary linkages in terms of employment, GDP growth, etc., and linked to the three basic ingredients of food, cloth, and house in human growth. About 250 ancillary industries such as cement, steel, brick, timber, building material, etc., are dependent on the real estate industry. The Indian real estate market is still in its infancy and largely unorganized. India's real estate market is expected to reach 180 billion US dollar by 2020 from 93.8 billion US dollar in 2014. Emergence of nuclear families, rapid urbanization and rising household income are likely to remain the key drivers for growth in all spheres of real estate including residential, commercial and retail. Previously, there was no well-defined regulatory regime in this sector in the country. In 2016, the pending bill regarding real estate was finally enacted as the Real Estate Regulation and Development Act of 2016. Hereinafter, I will refer it as RERA 2016. It is an open secret that real estate sector is filled with many fraudulent practices. Unfortunately, there is a spate of fraud cases involving the unscrupulous builders and gullible investors being reported almost every alternate day. Various types of real estate frauds. Generally, the dream of buying a home for a cheap price is exploited to cheat people. The process starts with misleading and false prospectus to lure maximum prospective buyers. Then the construction and real estate companies hire agents and brokers who display properties to prospective buyers. While some companies own disputed lands, many other often did not have any property in their name. In many cases, it has been seen that a construction company registers a portion of the land and displays that portion of land, claiming that an apartment complex would be built on the site. The registration document helps them to prove their intention and also a primary tool for befooling people with false promises. The same land then is shown to several people with the view to trap maximum number of investors to collect registration amount. After receiving the initial deposit and a few installments, the promoters and agents generally abscond in such cases. The sole purpose is to cheat people, showing them the dream of a house and the house remains in dreamland forever. The fraudulent practices can be of various types like fraud related to real estate transactions, identity theft, forgery, mortgage or loan fraud, theft of money or property, etc. Most of these fraudulent real estate companies, though unregistered, put out advertisement in leading newspapers and also on TV, which makes prospective investors to believe them. Some companies do not own single square foot of land anywhere but offer to sell land online. As the owners do not have any properties in their name, it makes recovery of money very difficult in such cases. It is unfortunate that so many people fall prey to dubious investment companies because of greed and the eagerness to make quick money. It is recent In a recent case, NK Real Estate Company cheated over 400 people to the tune of 200 crore by selling them property located on the Elephant Corridor, which did not have any approval from the government. The second case is the Temple Rose Group has also deceived many investors through the Pingodi project and others and has worked on a similar modus operandi multiple times. The Economic Offences Wings has also registered a rupees 90 crore investment fraud case against Temple Rose Real Estate. In another case of cheating, 5 directors, including 3 family members of Temple Rose Real Estate, have been booked for promising investors to double their money by giving land papers as surety. Unfortunately, buyers are either ignorant about the rules or unconcerned about compliance and end up losing money. The real estate firm Siddhi Vinayak Developers Private Limited had promised customers to hand over flats in 2 years after taking around rupees 10 crore from them in 2011, but never handed over it. From the perspective of investment, also people invest hefty amount in real estate sector. Many a times investing their entire lifetime savings. To regulate this sector, RERA seems to be a boon. However, it will again depend upon the proper implementation of the provisions of this act, that how much fruitful the act will be in reality. RERA is a comprehensive piece of legislation which actually tries to cover all kinds of issues related to real estate, starting from the registration of promoters and real estate agent to prescribing penalty for the promoter, real estate agent as well as the allottees for their default. Prior to the commencement of RERA, there were plethora of legislations, but the situation was highly unsatisfactory. Recommendations were made via various reports for major amendments into the existing laws so as to make them suitable for modern day requirements. The central laws governing real estate sector includes RERA 2016, then the Indian Contract Act, the Transfer of Property Act, the Registration Act, the Special Relief Act, the Urban Land Ceiling and Regulation Act, the Land Acquisition Act, the Indian Evidence Act, the Rent Control Act, state laws governing real estate, taxation laws, Stamp Duty Act, etc. When the real estate bill was not enacted in Maharashtra, the Maharashtra Housing Regulation and Development Act 2012 was applicable. For the sake of uniform application across the country, the said State Act is now repealed. Article 254 Clause 2 proviso of the Constitution of India. Ministry of Housing and Urban Poverty Alleviation constituted a committee in the chairmanship of Sri Dhanendra Kumar. The committee submitted its report on streamlining approval procedures for real estate project 2012. This is a very comprehensive report on real estate projects. The Planning Commission's 10th 5-year plan from 2002 to 2007 dedicates a complete chapter, that is 7.6, the name of the chapter, on real estate. It provides a detailed report covering almost all sphere of real estate sector. It also provides various legislations in this regard and also discusses the problem associated with some of these provisions. It also highlights the benefits if this sector is regulated properly. In short, it talks about the socio-economic issues attached with real estate sector. The Real Estate Regulation and Development Act of 2016 was published in the Official Gazette on 26 March 2016 for public information. However, it is interesting to note that all the sections of this act has been notified on 30th April 2017. The reason behind this was the institutional structure, namely the establishment of the regulatory authority and the appellate tribunal within 1 year of the commencement of the act are necessary prior to their enforcement. For example, projects can only be sold after they are registered with the authority. Thus, in the absence of the same, there would be a vacuum. However, for speedy implementation of the Act, Section 20 empowers the appropriate government to appoint an interim regulatory authority until the establishment of the full-time authority. RERA covers both residential and commercial real estate. RERA 2016 is intended to achieve the following objectives. First, ensure accountability towards allottees and protect their interest. Second, infuse transparency. Third, ensure fair play and reduce frauds and delays. Fourth, introduce professionalism and pan-India standardization. Fifth, establish symmetry of information between the promoter and allottee. Sixth, imposing certain responsibilities on both promoter and allottees. Establish regulatory oversight mechanism to enforce contracts. Then establish fast track dispute resolution mechanism, and finally promote good governance in the sector, which in turn would create investor confidence. As RERA 2016 is a newly enacted legislation and all provisions of this act will start functioning only from 1st May 2017 and will not only cover the new launches but also the ongoing projects where the completion or occupation certificate has not been received, but allows the period of 3 months to the promoters to get their ongoing projects registered with RERA until 31st July 2017. It is presumed that if RERA 2016 is implemented in true sense in its letter and spirit, then this sector will no more be unregulated as before and will be beneficial for all the stakeholders and will try to take care of their respective concerns. RERA 2016 provides not only the registration of real estate project mandatory but also the registration of promoter and real estate agent is a must. Without registration, they cannot move with the project, and the registration process itself requires lots of information to be furnished. Under the Act, including the past and present status of projects launched by the promoter, these provisions were included in the Act for efficiency and transparency. Without registering the real estate project with the Real Estate Regulatory Authority, hereinafter referred as authority established under this Act, no promoter shall advertise, market, book, sell or offer for sale or invite persons to purchase in any manner any plot, apartment or building in any real estate project or part of it. In any planning area, the promoter shall also have to make an application to the authority for registration of the ongoing projects as well as those projects for which the completion certificate has not yet been issued. within a period of 3 months from the date of commencement of the RERA 2016. Not only this, even if the authority thinks necessary in the interest of allottees for projects which are developed beyond the planning area, but with the requisite permission of the local authority, it may give direction to the promoter of such project to register with the authority. And the provisions of this act or the rules and regulations made thereunder shall apply to such projects from that stage of registration. The authority shall operationalize a web-based online system for submitting applications for registration of projects within a period of 1 year from the date of its establishment. The mechanism for registration, that is the requisite forms to be filled, the fees to be paid, etc., are to be determined by the rules made by the appropriate government. Within 30 days of the application having been received by the authority is required to register the project. In case the authority fails to take a decision within the said period of 30 days, in that case the project shall be deemed to be registered. RERA provides that real estate agents engaged in selling projects can only do so after registering themselves with the authority. The mechanisms for registration, the fees payable, the period of registration, subsequent renewal, etc., are matters to be detailed wide the rules. RERA also provides for detailed functions and duties of real estate agents. RERA is a step forward towards reforming the real estate sector in India, encouraging greater transparency, citizen centricity, accountability, and financial discipline. The promoter is responsible for the veracity of all information contained in the advertisement and the prospectus. In case of any loss sustained by any person due to false information, the promoter is liable to make good the loss sustained due to the promoter shall be liable for 5 years from the date of handing over of possession of the allottees towards structural defect or any other defect. The allottee would be compensated by the promoter due to delay in completion of the project, etc. Projects exempted from the ambit of RERA. Generally, where the area of land proposed to be developed does not exceed 500 square meters or the number of apartments proposed to be developed does not exceed 8 inclusive of all phases, registering the real estate project with RERA or Real Estate Regulatory Authority established under RERA is not required. However, if the appropriate government considers it necessary, it may reduce the threshold below 500 square meters or 8 apartments, as the case may be, inclusive of all phases for exemption from registration under this Act. Where the promoter has already received completion certificate for a real estate project prior to commencement of this Act, then also registration is not required. RERA also exempts registration for the purpose of renovation or repair or redevelopment which does not involve marketing, advertising, selling or new allotment of any apartment plot or building under the real estate project. However, where the real estate project is to be developed in phases, every such phase shall be considered a standalone real estate project and the promoter shall obtain registration under this Act for each phase separately. However, the authority may revoke registration or of a project after providing reasonable opportunity of being heard. RERA envisages two situations within which the registration granted to a project can be extended in case of force majeure, which means that in case of war, flood, drought, fire, cyclone, earthquake or any other calamity caused by nature affecting the regular development of the real estate project. And second is, it can also be granted under reasonable circumstances without the fault of the promoter, which shall not be more than a maximum period of 1 year. Section 32 of RERA provides various functions of the authority for promotion of real estate sector in order to facilitate the growth and promotion of a healthy, transparent, efficient and competitive real estate sector for the promotion of interest of the allottees. Promoter and real estate agent. The building approval process in India is relatively slower and more expensive in comparison to several other countries. In India, various types of approvals are required at different stages by different authorities. Development authorities allocate approvals based on land use and zoning regulations, while municipal corporations are responsible for the enforcement of building regulations as stipulated by the National Building Code. Accordingly, several non-planning permissions are also required to be obtained from various authorities such as the Traffic and Coordination Department, Airport Authority of India, Coastal Regulatory Zone authorities, etc., as an assurance that buildings do not adversely affect its surrounding area. Permits are also needed from utility departments such as Water and Sewerage Department, Electricity Board, etc. Additionally, a FICCI research report streamlining approval procedure for real estate project carried out across 5 states. It also suggests that it takes anywhere between 2.5 to 4 years on an average to acquire the necessary building approvals. McKinsey report also states that the cost of building approvals alone accounts for 40% of the sale value of units. As per a World Bank report 2012, India stands at 181st rank in the ranking of 183 economies on the case of dealing with construction permits. National Real Estate Development Council was established as an autonomous self-regulatory body in 1998 under the aegis of Ministry of Housing and Urban Poverty Alleviation, Government of India. It was formed with the mandate to induce transparency and ethics in real estate business and transform the unorganized Indian real estate sector into a matured and globally competitive business sector. The government should permit the setting up of a real estate investment trust, which should be regulated by SEBI in order to open the investment floodgate for the real estate sector. Real estate investment trust and infrastructure investment trusts are investment vehicles that can be used to attract private investment in the infrastructure and real estate sectors and also relieve the burden of formal banking institutions. The appropriate government is required to constitute the real estate regulatory fund. Grants received by the authority, fee received under the act or rules and the interest accrued thereon shall be credited to the real estate regulatory fund. However, penalties received or recovered under this act are to be deposited in the Consolidated Fund of India in case of the authority established by central government and in case of state account in case if it is the authority established by the state government. The accounts of the authority are required to be audited by the Comptroller and Auditor General of India and to be laid before the Parliament or the state legislature as the case may be. The authority is also required to prepare an annual report to be forwarded to the appropriate government for it to be laid before the Parliament or the state legislature as the case may be. The vision for future consists of a one-stop shop or single window clearance as all regulatory authorities at the central, state and local government levels are connected by a robust technology platform. This single window would allow single payment to be made electronically against a composite application form for multiple services and the subsequent splitting and routing of payments to individual departments and agencies. Now coming to protecting consumer interest across the approval process. Through consumer protection laws, though consumer protection laws are available, the recourse available therein are only curative but not preventive. A state should consider appropriate mechanism to regulate building construction activities with a twofold purpose. The first purpose is to ensure consumers are not duped by investing in projects that do not have necessary approvals in place, and second is to avoid high incidence of mishaps and accidents because of poor building standard and quality. Twitter campaign fighting for RERA. There is a Twitter campaign launched by a large number of home buyers group regarding some states diluting key provisions of RERA. States like Maharashtra and Madhya Pradesh have diluted some rules with respect to builders submitting sanction plans and selling open areas. Karnataka and Tamil Nadu have all drafted rules violating the Act's mandate. States such as Uttar Pradesh and Haryana proposed not to cover some ongoing projects in its final RERA rules, while Gujarat proposed to only cover projects launched after November 1, 2016. Through Twitter campaign, a large number of apartment buyers are calling for implementation of RERA. Majority of states have come up with the RERA rules. However, some states are still in the process of making RERA rules. There is a big question mark whether the states have followed the RERA 2016 in its totality while framing respective rules or not. Still, the position is not very clear. Recently, the Haryana government has hinted that it might set up a dedicated or exclusive body under RERA for Gurgaon, as it accounts for more than 90% of real estate deals in Haryana. However, the industry body Naredco said it would be preferable to have a regulatory authority for the entire state rather than focusing just on Gurgaon. Procedure for filing complaint. Complaint may be filed before regulatory authority under section 31 or adjudicatory authority under section 12, 14, 18 and 19 of RERA. Section 29 provides the disposal should be within 60 days or reasons to be recorded for non-disposal. Appellate tribunal is the real estate appellate tribunal under section 43, and section 44 provides for disposal within 60 days or record reasons for non-disposal. After this, the complainant may file an appeal to the High Court. The civil courts are barred from entertaining disputes or suits or proceedings in respect of matters which are within the authority or the adjudicating officer or the appellate tribunal is empowered under the Act to determine. However, the consumer forums, national, state and district have not been barred from the ambit of this Act. An aggrieved can approach any one of the two, that is authority under RERA or consumer forum, for disputes over the same matter. Penalty under RERA 2016. RERA provides penalty for defaulters. Interestingly, if any person is punishable with imprisonment under the Act, the same may be compounded on such terms and conditions which may be prescribed by rules made by the appropriate government. In addition, the fine payable in lieu of imprisonment needs to be specified by the said rules, which cannot be more than the maximum fine payable for that offence. Supreme Court on real estate fraud cases 2017, miles to go. Honorable Supreme Court has dealt with many real estate cases recently. As the Act has been newly enacted, there are several pending cases like DLF case, Unitech Promoters Vistas project case, JP Infra's Noida's Aman project, Sahara's Ambi Valley case, etc. Once these cases are finally adjudicated, then it will pave the way for clarity in this sector. Spreading awareness. Ignorantia juris non excusat means ignorance of law is no excuse. Unfortunately, about RERA, everyone is not fully aware of, even those on whom it applies. The public should should be aware and ask for documents and clearances from the companies before booking a house. This may be included as part of the Citizens Charter, and publicity leaflets and campaigns on such issues may be considered by state and local bodies. The Economic Offences Wing has started a welcome step by distributing pamphlets on various types of financial scams and how they could escape from it, and has put up posters in various public places to ensure that people are aware of such offences. Conclusion: the expectations from RERA are huge as it will change the way the real estate sector functions, but there will be challenges initially. The pain of the transition will be there because it's been a sector which has been under no regulation for so long. The Act will bring relief to thousands of home buyers, promoters, and real estate agents across the country that are facing issues of delayed possession and other problems associated with real estate sector. In an environment wherein home buyers have low trust in under construction properties because of delays in delivery, this law will help bring in clear accountability of developers and lead to greater optimism of home buyers. Lastly, to conclude, this can be said that RERA 2016 is a progressive legislation with a vision to regulate real estate sector and to safeguard the interests of various stakeholders at large. However, its efficiency would be adjusted in time to come. I just hope RERA will be able to achieve its desired goal. Thank you so much for patient hearing.